All right. Greeting, boys and girls. This is Dr. Ellinger, and we are discussing your Chapter 13 questions. So I'm not wearing a special costume this time because several people said last time for me to stay safe in Hawaii, and one even inquired as to what kind of airline and hotel deals I was able to get. So clearly some of you were faked out by my Hawaii references. I found it was interesting that a lot of people thought I was actually in Hawaii when we had my messy office and all these bobbleheads in the background, and I would have figured it was pretty obvious I wasn't in Hawaii. So we're not doing that again. But today is my tribute to Barack Obama, so I've got my Obama bobblehead and, of course, the hat, Make Our President Black Again. Looks just like one of those MAGA hats that Trump likes to give out. So anyway, the hat was one of my favorite gifts from a former student, and the Obama bobblehead is one that I bought myself. So without any further ado, let's get into your questions. Hey, one thing I want to mention, the email I sent out a day or two ago talking about all those videos, there were 9 of them from Chapter 4. Actually, there was only 7 of them. The last 2 that I mentioned, which is Crash Course number 30 and Crash Course number 31, those are actually from the Civil Rights chapter, which is Chapter 5, because they both deal with discrimination. So I should not have included them in the Chapter 4 videos. So actually for Chapter 4, it only goes through video number 29. So it's 23 through 29. Yeah, Crash Course number 23 through Crash Course number 29 are the only videos you need to see. And 30 and 31 will be part of the Chapter 5 videos, which I'll be sharing with you next week. Okay, now let's get into your questions. This first one, the 4 weaknesses of courts in America, from class notes. So it's a little hard to find these in this book, so let me just give you the 4. Number 1, judges are not elected, so they often restrain themselves from ruling in very political cases. It's called judicial self-restraint, and sometimes if it's a controversial issue or one where the public has a really strong feeling, they will not even take the case and allow the political branches of government, like the president and Congress, to deal with the issue. This is the political question doctrine, and so historically they have declined to take the case and said basically it was a political question. Nowadays, they are more likely to take politically charged cases. They don't worry as much about how political it is. Okay, number 2, lack of jurisdiction. So many times courts will not take a case because they say they don't have jurisdiction over that particular type of case. So this concept of jurisdiction is very important on the exam. And jurisdiction just simply means certain types of courts only hear certain types of cases. So you might have a case appealed to the U.S. Supreme Court, and they'll say, we're not taking this case because this is a state issue, and they tell the people to file a suit in state court and take up the issue there. So that's a good example of the concept of jurisdiction, and it's definitely a weakness of courts, or just maybe the better is a limitation on the power of courts, which basically is a weakness. Okay, here's an important one. Courts do not have what's called a self-starter, which simply means this: they have to wait for a case to be appealed to them. They cannot initiate a case themselves. They have to wait for somebody to file a lawsuit, and in the case of the Supreme Court, it goes through a trial court, then it goes through the appellate court, and finally it gets to the Supreme Court, and it might take a year or 2 or 3 years or even longer. So, you know, if you think about Congress and the president, if they see an issue that needs to be addressed, they can basically pass a law, the president signs the law, or the president can issue an executive order, and they can do it almost immediately, or at least very quickly. Courts have to wait. They can't initiate anything. They always have to wait for a dispute to be brought to them. And the last one, courts often cannot enforce their decisions. They make a ruling, but other people have to enforce the decision. The president, Congress, a governor, a state legislature. And so many times in history, federal courts have ruled and nothing really changed. The best example is Brown versus Board of Education, maybe the most famous Supreme Court case of all time. It's the one that said, we'll be talking about this more in Chapter 5, the Civil Rights chapter, but just quickly here. Brown versus Board said blacks and whites must go to school together. No segregated schools. It took 16 years for the last segregated schools to finally disappear in the South. So that decision was 1954. Segregated schools continued in the South until 1970 in some places. Even in Dalton, for example, the all-black Emory Street School was still graduating high school students in the spring of 1968, 14 years after Brown versus Board. And finally, black kids went to school with white kids when the new Dalton High School was built and opened in the fall of 1968. So that's a great example of how the courts, and especially the federal courts, often cannot enforce their decisions, and it takes a long time, and sometimes it never happens. The court decision simply gets ignored, and the court sometimes can't do anything about it, often can't do anything about it. Okay, so those are the 4 weaknesses of courts in America. That's plenty enough to know for the exam. The 3 functions of courts in America. They settle disputes. Okay, that's one of the most important things courts do. I've got a problem with somebody, so I sue them. That's an example of civil law. No one's going to prison. It's not a violation of a law. It's simply a disagreement between 2 parties, and one sues the other, and they let the courts decide who's responsible for what, and if damages have to be paid, or, you know, something has to be done to settle the dispute, courts can order that. That's an example of civil law. Criminal law is when somebody violates the laws that are designed to protect society. This is also a form of settling disputes. And of course, in the case of criminal law, if somebody is found to be in violation of one of the criminal laws, either a state criminal law or a federal criminal law, then they most often will go to prison, or at least pay a big fine. So, courts settle disputes. Courts also create expectations for future behavior. So people look at court decisions and they see that the court ruled against somebody, and they always have to give a reason, which is called the court's opinion. And you can read the court's opinion and see that if you engage in the same kind of conduct as this person did who just lost the lawsuit, then you're also going to lose if somebody sues you. So you alter your behavior to make sure you don't do those things. So courts settle disputes. They create expectations for future behavior. And of course, they protect society. Settling disputes is an example of civil law. Protecting society is an example of criminal law. That's the one that we're most familiar with. We know there are bad people out there who do bad things, and they must be punished and sometimes taken out of society to protect the rest of us. Okay, now, one last thing. Part of this whole function of protecting society or settling disputes is an example of interpreting the law. So courts interpret laws. They interpret the criminal laws, they interpret the civil laws, and they apply often a broad, vague law to a specific situation. And that requires an interpretation of the law. Laws are written, but they seldom deal with the particular circumstances of a dispute. And so courts must interpret the law and apply it to a very specific situation. Okay, so those are the three functions of courts in America. Know the four main steps in the path that a Supreme Court case follows. Here we go. The first one is briefs are filed. Now, there are more than four steps in the path a Supreme Court case follows, but for purposes of our test, I'm boiling them down to the biggest four. This is all you need to know. The lawyers first file briefs. Those briefs are submitted to the Supreme Court, and they simply an explanation by a particular side, either the plaintiff or the defendant. And you'll get 2 points for knowing that the plaintiff is the one who files a lawsuit. They bring the case to court, and the defendant is defending themselves from the allegations made by the plaintiff. So both the plaintiff and the defendant are going to file briefs before the Supreme Court, giving their own theory of the case and how they think the Supreme Court should rule. All right, the second one is there is a judicial conference. The 9 judges meet all by themselves in a room, and they discuss the cases that have been submitted to them. There could be 8,000 to 10,000 cases a year sent to the Supreme Court on appeal. The Supreme Court is generally an appellate court, which means they hear cases that have been appealed from the lower levels of the federal court system. And remember, the 3 levels of the federal court system, which were created by the Judiciary Act of 1789, is United States District Court. That's called the trial court. And in a trial court, evidence is heard, and there's going to be some kind of determination of guilt or non-guilt, or responsibility or no responsibility. So in a civil case, a trial court, which is called a court of jurisdiction, as I said, is going to determine, say in a criminal case, is somebody guilty or not guilty of the charges brought before them. In a civil case, they're going to look at the question of responsibility. Is the defendant responsible for the damage that's alleged by the plaintiff? Okay, so if I think somebody has ripped me off, or if I think somebody has taken advantage of me, or they've done something that I don't like, I can sue them, and I would be the plaintiff, they would be the defendant, and a judge just is the defendant responsible for the damage suffered by the plaintiff. If they are, they can order some sort of a remedy, some sort of a fix. If they decide that the defendant is not responsible for the damages suffered by the plaintiff, they can simply dismiss the case, and the plaintiff loses, and the defendant doesn't have to do anything, doesn't have to pay anything. So, back to the 4 steps in the path a Supreme Court case follows. So as I said, first is the filing of the briefs. Second is the judicial conference, where the 9 justices discuss the cases that have been appealed to them. And step 3 is super important. There's more than one question about this. The judges always vote on which cases they're going to hear. So as I mentioned a second ago, there might be 8,000 to 10,000 cases appealed to the Supreme Court, and they're typically going to hear maybe 80 to 100 of those cases. So they're going to hear at most maybe 1% of all the cases appealed to them. And the way they sort of eliminate the other 99% is they vote on whether or not to hear the case. And if they decide to hear it, they issue what's called a writ of certiorari, certiorari, a writ of certiorari. And that requires 4 of the 9 justices. 4. It's called the rule of 4. If 4 of the 9 justices decide to hear a case, then the Supreme Court will hear that case. If that case doesn't get 4 votes, then certiorari, which everyone calls cert, because certiorari is hard to spell and hard to say, cert will be denied. So when the Supreme Court refuses to hear a case, they never give the reason why they refuse to hear it. They'll just say blank versus blank, cert denied. That's all they say. They don't give a reason for why they're not taking the case. All right. What are the 4 types of law? And know just a little bit about each one. I would say 1 sentence is enough to know about each one. The first type of law, you can think of it as a pyramid, and this is the bottom of the pyramid. The first type of law is called common law. Now, common law is judge-made law based on the customs and traditions of a particular society. So, common law in America is based on English common law. Roughly 1,000 years ago in England, judges, there was no written law, okay? So there were not laws passed by Parliament. Parliament didn't even exist until like 600 years after that. Basically, if somebody thought they were harmed by somebody else, they would take the case to court, and a judge would look at the facts of the case and make a ruling that they thought was fair. And they generally wrote down what their reason was for ruling the way they did, which is called the court's opinion. And we're going to talk in a minute about why a court's opinion is more important than the court's decision. But they issue an opinion, which is basically a statement of why they ruled the way they did. And as a result, the court's opinion sets a precedent, and a precedent, P-R-E-C-E-D-E-N-T, precedent, different than the word president. A court's opinion sets the precedent. And that means future courts will generally rule the same way that a previous court ruled in a case that's basically almost identical to that previous case. So courts don't like to overturn a precedent set by an earlier court decision. People need to be able to anticipate how a court's going to rule. And so generally, judges follow the precedent that was set by previous judges in similar cases. Okay, so 4 types of law. The first one is common law, as I said, judge-made law based on customs and traditions. And number two, which builds on the common law, is called constitutional law. So if you look at the U.S. Constitution, there's not really anything in there that would be inconsistent with the common law. Okay? So English common law, as I said, is the basis for common law in America. And anything in the Constitution is going to be consistent with the common law. Okay? So the Constitution is going to be more specific than the common law. Now, the next level, which is the third level, is, the third level is the kind of law that we're most familiar with, laws that are passed by legislatures, like the state legislature or Congress, and that's called statutory law. When Congress or the Georgia legislature passes a law, it's called a statute. They write it down in the statute books, and that's what most of us think of as the law. A law was passed by the Georgia legislature, signed by the governor, and we all have to obey it. Or a law was passed by Congress, signed by the president, and we all have to obey it. Statutory law. Now, the fourth level, and obvious statutory law is more specific than constitutional law, but it has to be consistent with constitutional law, or else the Supreme Court will say this statutory law is unconstitutional. And they do that usually at least a couple of dozen times every single year. They find that a law that was passed by the Georgia legislature, the Tennessee legislature, or maybe even Congress is inconsistent with constitutional law, and they declare it unconstitutional, and that law disappears. Now, the fourth type of law is the one that you're probably least familiar with, but it's the fastest growing type of law. This type of law is just exploding in America, and it really accounts for why we have so many lawyers in America. And this is called administrative law. Let me fix this. Okay, administrative law. When Congress or a state legislature passes a law, it has to be interpreted by the governor, carried out by the governor, which means implemented, or implemented by the president. And as a result, the governor or the president will order other government agencies in the executive branch to carry out the law the way the governor or the president think it should be carried out. And that is extremely important because laws are often pretty vague, and as they say, the devil is in the details. And so administrative law is simply carrying out the laws passed by legislatures. Let me give you an example. Congress passed a law called the Social Security Act in 1935. It created the Social Security system that we're all familiar with, but it also created something else called disability law. So Social Security disability is, say you've been hurt and you can't work, then Congress wanted you to still get a check from the federal government so you can still survive now that you're too injured to actually work for a living. And so people apply for Social Security disability all the time. And many times they are denied by the federal government. And so what happens is they hire a Social Security disability lawyer. These guys advertise on TV all the time. And they will essentially sue the Social Security Administration on your behalf. And that case will be heard by a Social Security administrative law judge. So the administrative law judge is going to look at the Social Security disability laws, apply it to your particular situation, and see if you're entitled to a Social Security disability check. And many times, this happens usually more often than not. The federal government initially turns you down for Social Security disability. You hire a lawyer, the case goes to an administrative law judge who only hears Social Security disability cases. And more often than not, the judge will rule in your favor and say the federal government has to send you a Social Security disability check. They rule against the federal government's decision to not give you a check, and they rule in your favor. So you wind up getting Social Security disability, and generally you'll get that monthly check for the rest of your life because you're too injured to work. So that happens all the time, that federal government agencies issue rules and regulations, and some people don't like those rules and regulations, and so they basically sue the federal government, and these cases are always heard in an administrative law court, where basically a judge will look at how the federal government is interpreting or carrying out a law passed by Congress, and they'll either rule in favor of the plaintiff, which say might be me if I'm applying for Social Security disability, and they could rule in my favor. The government has to give me a check. Or they could rule against me and say the government was right in denying me a Social Security disability check, and I have to live with that because there is no other place for me to appeal an administrative law decision. So, the four types of law. The four types of law are common law, constitutional law, statutory law, and administrative law. So we go from the most general type of law, the most vague and general type of law, which is common law, all the way to the most specific type of law, which is administrative law. All right, let's see if I can do it that way. All right, I think that's better. Okay. Know the difference between a court's decision and a court's opinion. I can tell you right now, the court's opinion is more important than the decision. Almost every single time. The opinion is more important than the decision. And the reason is decisions do not set a precedent. Opinions set a precedent. So, Brown versus Board of Education, the case I referred to earlier, maybe the most famous Supreme Court case in U.S. history. Linda Brown sued the Board of Education of Topeka, Kansas. And here's what the Supreme Court could have ruled. They could have ruled in favor of Linda Brown in their decision and said, Linda Brown can attend an all-white school because her house is located closer to the all-white school than the all-black school. Now, that would have still been a victory for Linda Brown. So the decision is really only affecting Linda Brown and the Topeka, Kansas Board of Education. But in the Supreme Court's opinion, they said, we're not only going to rule in favor of Linda Brown, we're going to rule in favor of all black children. We don't care where they live. They could live right across the street from an all-black school, but they must attend an integrated school rather than a segregated school. So they wrote the opinion broadly enough that it applied to all black school children rather than just Linda Brown. So the decision in the case was a victory for Linda Brown. The opinion was so broad that it applied to all other black children also, and that was the precedent that was set, and that's what changed America forever. So I think you can see that the court's opinion is way more important than the court's decision. certainly in most cases. All right. Because it's all about the concept of precedent. Precedents are set by a court's opinion and not generally by the court's decision. Okay. Know the basic facts about the structure of the federal court system and what each of the three levels do. First of all, let's talk about the concept of a constitutional court versus a legislative court. In Article 3 of the U.S. Constitution, which deals with the courts, the only court that was created was a Supreme Court. That's why it's the only constitutional court. So basically, Article 3 said there shall be a Supreme Court and whatever other courts Congress wants to create. And the very first Congress, which met in 1789, passed the Judiciary Act of 1789 that basically said there will be two other levels of the federal court system below the Supreme Court. And so the trial court, which is the lowest level of a court system, a trial court is called a court of original jurisdiction. So that means the case first goes to the trial court. And the trial court in the federal judicial system is called U.S. District Court. So for example, if you are accused of breaking a federal law in Dalton, your case will be heard by the U.S. District Court in Rome, Georgia. And let's say that the U.S. District Judge in Rome says you're guilty of violating a federal law. There's a concept called the due process of law, very important, mentioned on this test more than once. Due process means the case is never over just because you were found guilty. Due process says you have a right to an appeal because the judge might have made a mistake. So you can appeal to the appellate court, the appeals court, and in the federal court system, that's called the Circuit Court of Appeals. So for example, we have 94 different district courts in America, like the Northern District of Georgia is in Rome. And if you appeal, you can appeal to one of the 12 circuit courts in America. And in our case, if you want to appeal your defeat at the U.S. District Court in Rome, you would appeal to the 11th Circuit Court of Appeals, which meets in Atlanta. And so anybody who wants to appeal an unfavorable decision from a federal court in the states of Alabama, Florida, or Georgia would appeal to the 11th Circuit Court of Appeals in Atlanta. And they are required to hear the case because you have a due process right for your case to be heard by an appeals court to make sure that the district court judge ruled properly and applied the law, federal law, and the Constitution properly. So let's say the 11th Circuit upholds your conviction in district court. Do you have to appeal to the U.S. Supreme Court? And the answer is yes, you do. So you might remember we talked earlier about appeals to the Supreme Court, and basically the Supreme Court is not obligated to hear your appeal, to grant your appeal. In fact, there's a 99% chance they won't grant your appeal. You've already had your due process right protected because your case was heard by the Circuit Court of Appeals. So you're actually only entitled to one appeal. Now, if the Supreme Court wants to hear your appeal, they can grant the writ of certiorari and rule in your case. But they're not obligated to do that. They can do it, they cannot do it, and generally they won't do it. So for the Supreme Court to hear a case, generally there has to be an important constitutional question involved. And if your case doesn't pose an important constitutional question, then they generally won't take the case. Okay, so 3 levels of the federal court system. The lowest level, where all the cases originate is U.S. District Court. Then cases can be appealed to the circuit courts of appeal, and then they can be appealed beyond that to the Supreme Court, but the Supreme Court is usually not going to hear the appeal. You've got about a 1% chance. Okay, so how does the Supreme Court decide what cases to hear on appeal? Well, let's just look at one of the questions here. Which of the following is not one of the types of cases that are heard in federal court? Well, to get that one right, you got to know the 3 types of cases that are heard in federal court. So, cases that require an interpretation of federal law or an interpretation of the U.S. Constitution, those cases are heard in federal courts. How about cases that involve disputes between the states or between the states and the federal government? So like right now, water rights to the Chattahoochee River are the subject of a federal court lawsuit involving Alabama, Florida, and Georgia, because the Chattahoochee goes through all 3 states. And Alabama and Florida think that Georgia is using too much of the water of the Chattahoochee and they're polluting it. Probably both of those things are true. But Georgia, of course, says we're not using too much water. The Chattahoochee mostly runs through Georgia. And they say that Atlanta is not polluting the Chattahoochee. And so that's why that case was heard in federal court. And it may well wind up before the U.S. Supreme Court. The President of the United States for years now has been trying to get the governors of the 3 states to reach some sort of an agreement, but they have not done that. It's been like a decade and the states just can't agree. So that case will probably wind up being heard by the Supreme Court because it involves disputes between states. Also, if the federal government told Atlanta to stop using so much of the Chattahoochee water, Georgia could sue the federal government. And that's also a type of case heard in federal courts. The U.S. government is often sued by a group or an individual, or the U.S. government may sue a group or an individual. So cases that involve the U.S. government as either the plaintiff or the defendant, those cases are heard in the federal courts. So those are the 3 types of cases heard in federal courts. Let's see. What are the 3 main types of Supreme Court opinions? Well, there are more than 3, but for our test purposes, we're going to look at the big 3. And the most important type of Supreme Court opinion by far is the majority opinion. The majority opinion is basically the ruling of the Supreme Court. It's the one that sets a precedent, and there have to be at least 5 of the 9 justices, which would constitute a majority. 5 of the 9 justices have to sign on to the majority opinion. And if there are 5, then that majority opinion will always set the precedent. Now, what if you're a justice who agrees with the opinion of the court, but not for the same reason as the other justices have? You could refuse to be part of the majority opinion, even though you're voting with the majority, and you can issue your own opinion. You would not sign the majority opinion. That's called a concurring opinion. The word concur means to agree, but in this case, agree for a different reason. So concurring opinions are very important. And finally, what if you are a Supreme Court justice who votes on the losing side of an issue? You always have a right to issue a dissenting opinion. Dissent means to disagree. So a dissenting opinion will basically be the reasons why you think the majority is wrong and you voted with the minority. Okay, so those are 3 types of Supreme Court opinions that you need to know for this test anyway. What is an amicus curiae brief? Typically just called an amicus brief. Amicus is a Latin word for friend, and so that's called a friend of the court brief. So let's take Brown versus Board. There were all sorts of black civil rights groups who wanted the Supreme Court to rule in favor of Linda Brown and apply it to all black school children. So they file a brief, an amicus brief, amicus curiae brief, to the Supreme Court, basically saying the Supreme Court should rule this way and here's why they should rule that way. There could be people who didn't want Linda Brown to win and didn't want it to apply to all black school children. So they could file an amicus brief on the other side, and the Supreme Court could take their brief that argues that segregated schools should be maintained, and that's what the brief would say. So in a really big Supreme Court case, it's not unusual for dozens and dozens of amicus briefs to be filed. It's the one way that a third party, not the plaintiff, not the defendant, but a third party can weigh in and try to influence the behavior of the Supreme Court, the decision and the opinion of the Supreme Court. So amicus briefs are important. 3 famous historical examples illustrating the problem with enforcing Supreme Court decisions. So these are probably the 3 most famous illustrations of that. They're all on the test. And the first one is the case I've been referring to multiple times, Brown versus Board of Education. And remember how I said that the ruling was in 1954, but it wasn't fully enforced until 1970? That illustrates a huge problem with enforcing Supreme Court decisions. Another famous example involved Abraham Lincoln and the question of due process. Part of the importance of the concept of due process is if you're arrested, you have a right for your case to be heard by a judge very quickly to just see if there's enough evidence to hold you over for a trial. And if the judge thinks there's not enough evidence, he will order you to be released and for the case to be dismissed. Well, Lincoln used his emergency powers during the Civil War and said, basically, we are suspending due process for the duration of the war. And they started rounding up anybody they thought was a Confederate spy in the Washington, D.C. area, might be spying on the federal government, trying to give the South tips on what the federal army might be doing, for example. And so Lincoln had a lot of these suspected spies rounded up. Now, some of them clearly weren't spies, but they were basically held in jail until the war was over. And the evidence that the federal government had against them was never looked at by a federal judge. So their due process was violated rather badly because they just got arrested and never got their day in court. Then when the war ended, Lincoln just released them all. But some of these people were in prison for the better part of 4 years. Okay, and the last one is the case of Andrew Jackson and the Cherokees in Georgia. In 1830, famous case Worcester versus Georgia. The Supreme Court said the state of Georgia cannot require the Cherokees to leave Georgia. And Andrew Jackson said, the Supreme Court has made its decision, now let it enforce it. And of course, the Supreme Court couldn't enforce it. So Andrew Jackson, as the commander-in-chief, sent a bunch of federal troops down here to round up the Cherokees and send them on their way in the infamous Trail of Tears. And the president got his way, and it directly defied a Supreme Court decision. And the Supreme Court simply couldn't enforce their decision in Worcester versus Georgia. So the president got his way. All right, the last one. And by the way, all 11 of these came from a really good student named Blair. So Blair, thank you for giving me these 11 things that were on the review sheet. because these are all really important on the exam, and I guess they were difficult to find in the textbook, because I think if they'd have been adequately explained in the textbook, then Blair wouldn't have asked these questions. So, last one. Examples of the relatively few types of cases that go directly to the Supreme Court. Remember I said earlier, the Supreme Court is a court of appellate jurisdiction, and basically that's true. Probably 99% of the cases are heard on appeal, but there are cases that go directly to the Supreme Court, which means the Supreme Court has original jurisdiction, and they essentially hold a trial at the Supreme Court level. And here are a few examples. When two or more states sue each other, that case goes directly to the Supreme Court. When a state sues the federal government, or vice versa, federal government sues a state, that goes straight to the Supreme Court. How about when a citizen of Georgia sues a citizen of Tennessee? That's an example of a case that would go directly to the Supreme Court. Basically, any case where you could imagine that a federal judge in one state might show preference for a plaintiff or defendant from their state, that really wouldn't be fair. So if I'm suing someone in Tennessee and a Tennessee federal judge hears the case, I'm going to think they're going to be biased in favor of the Tennessee person who maybe filed the lawsuit. And as a result, that case would go directly to the Supreme Court. Also, a case involving a foreign diplomat. So let's say a Russian diplomat is accused of rape. This is an actual case. So the Supreme Court would essentially hold a criminal trial and look at the evidence and see if this Russian diplomat actually raped this American woman. That's really kind of a waste of their time. They want to look at much bigger issues than that. Plus, it's really politically sensitive because, you know, we have diplomats in Russia, and maybe if the Supreme Court ruled against the Russian diplomat, then Russia might just arrest an American diplomat and hold a trial. That sounds exactly what the kind of thing that Vladimir Putin, the Russian dictator, would do. And so we don't really want to go there. And as a result, Supreme Court hardly ever hears a case involving a foreign diplomat. Instead, we just send the diplomat home. But we revoke his passport and he can never come back to America. But we would send him back to Russia and tell the Russians, you need to, hold this guy accountable. You need to take him to court and see if he's guilty of rape. And if he is, then you need to punish him. And if you refuse to do that, then that's going to really hurt U.S.-Russian relations. And I don't think you guys want to do that. So, the case of foreign diplomats is kind of difficult because I think a lot of times the foreign diplomat, say, comes to the United Nations in New York and they feel like, hell, I can get away with anything because I won't be held responsible by American law because I'm a diplomat. And a really funny example of that is parking. So you've got foreign diplomats who park illegally. Maybe they park in a handicapped spot and they feel untouchable, like New York City can't really enforce the parking laws against them because they have what's called diplomatic immunity. They are essentially above the law. And that's a huge problem in a city like New York that has hundreds of foreign diplomats. They do tend to disregard American law because they know the Supreme Court's not going to hear a case that applies to them. So here's what I'm going to do. This took a lot longer to get through Blair's 11 points. So I'm going to go ahead and stop the video right now. And I will do another video in the next, how about early next week, maybe Monday, because I don't want to bother Teresa Butori at home this weekend. She's the one who helps me with this technology. So I will ask Teresa to give me an appointment on Monday, And we will finish chapter 13 because there's a number of other questions that were asked by other people, and I still want to cover those. So we will cover those on Monday. I think this lecture has been long enough. So anyway, I hope this kind of thing is helping you guys, and I will see you again on Monday. Stay safe. See ya. Okay, now I got to figure out how to stop this thing. All right.